A conservative group is supporting Oracle as the company takes its copyright lawsuit against Google to the Supreme Court. One America's Jack Posobiec spoke with the senior advisor of the Internet Accountability Project about the case and has more from Washington.
Very excited to sit down once again here at One America News with Rachel Bovard, senior advisor for the Internet Accountability Project. Rachel, thank you so much for sitting down with us. And tell us, so you're now getting involved. You guys are getting involved in this huge tech fight at the Supreme Court between Google and Oracle. Why would you do something like that?
Yes, so we are doing it because we believe in free markets and we believe that cheaters deserve to be held accountable. And so we are filing on the side of Oracle. In the case Oracle v. Google, we are filing an amicus brief today in support of Oracle's case against Google, which basically says or asserts that Google stole 11,500 lines of their code to profit by making the Android mobile device. They used Oracle software without their permission, and now Oracle wants them to be held accountable.
So what's Google's response to all of this? I mean, it's pretty clear that the code is copy and pasted, I understand from reading it, but how is Google trying to respond and saying that it wasn't theft?
Right, yeah. Google doesn't deny that they used these 11,000 lines of code. They say, oh, well, this is fair use. There's a section of the copyright law which says you can copy other people's work if you're using it for innovation, research, free expression, or if you've transformed it sufficiently into a new product. Now, they're on shaky ground with this argument for two reasons. One, there's evidence that Oracle was in fact trying also to develop mobile, so they're not necessarily creating a new product. But second, Google went in and tried to license this code from Oracle. This was the first step in that process. So they recognized there was commercial value there, that this wasn't fair use. And when those negotiations stalled and Oracle walked away from the table, Google simply responded by stealing the code and then saying, oh, fair use. So they recognized there's a commercial value there. When it didn't work out, they tried to say it was fair use.
And so had other companies had asked for and received licenses for this?
That's right. Many other companies use this license to do this. Oracle can point to all these examples. So Google, this is a classic pattern for Google, which is if they don't get what they want, they simply go in, steal whatever IP it is, and then demand that these companies litigate them in decades-long cases in court, which is the case here with Oracle. They've been embroiled in litigation over this for 10 years. Most companies go out of business. Most companies can't afford to fight Google.
But if you're a startup and you have this innovative code or this innovative breakthrough, and then Google comes and steals it, what are you going to do?
That's right, and Google banks on that. They rely on the fact that these companies can't compete with them in court. Oracle can. They are the exception, but they're one of many companies that have been in this situation. Sonos, the speaker company, is now suing Google, making the same case that Google stole their speaker technology. And the head of Sonos has said, we may not be able to fight them to the end. We may simply go bankrupt in doing so, but we think it's important to take a stand.
Now, what would be the repercussions should Google lose this case?
Well, Google will be forced to actually play by the rules. They will be forced to work the way the rest of us do in the free market, which is if you see an innovative technology, you either out-innovate it and compete, or you license and you don't just steal. Google has made its entire business model in many cases off of just stealing other people's creativity. They will no longer be able to do it. I would suggest that that's what a free market looks like. So if Google loses this case, there'll be an actual free market in tech, as opposed to just Google bullying, dominating, and cheating its way into market ownership.
And I understand that the government is also getting involved in the case. What side are they getting involved for?
So the government is going to argue that this isn't fair use. So they are going to argue Oracle's claim, which is essentially Google didn't have a right to this, that copyright law matters in this case. This doesn't constitute fair use. This is a property rights argument before it is anything else. And so that's the claim I think they'll be making.
What's the next step in the case?
Well, it'll be heard next month before the Supreme Court. So buckle up. It's about to get real for all the older justices. They're going to hear a lot of tech cases next month.
All right. Well, I think property issues, copyright law, that's something that's even older than the United States itself. Rachel Bovard, thank you so much for being on. We'll definitely have you back when this case goes to court.
Thank you.
Thank you.
Want to see more videos like this? Click on the link below and subscribe to One America News on YouTube. And call your cable provider and kindly demand that One America News is added to your lineup. Call and subscribe today.